Two things, Mr. Laney. First is that transcribers as well as judges probably get more tired in the afternoon, so we will take a short break at 3:15. And second, I've been told that the transcribers are not picking up everything you say. I don't know if that message has reached you.
It has. We think it's because I'm a bit shorter than Mr. Matthews. Mike's there. Well, I can shout a bit louder, but I don't want to deafen.
We're having no difficulty in hearing you. Anyway, if you've been told, no doubt you'll do whatever you can.
I'll do what I can. I'm not sure I can grow, which I think is the actual solution.
I'm not going to make any suggestion.
My Lord, before the break, I said I would come back to my Lord Justice Nugee on the other case I had in mind on the standard.
Yes.
And it was, the case I had in mind was the Kukurian case, which is tab 46 of the authorities bundle, which I think is your volume 5.
Yes.
And it's paragraph 19, which is the relevant paragraph.
This was a contempt case, wasn't it?
It was. And so what Lord Justice Warby, I think it is, did was, if you go back to the beginning, he sets out that it's a contempt case, sets out at paragraph 10 the nature and purpose of the civil contempt jurisdiction. 12, the burden and standard of proof. And he carries on to deal with all the relevant elements, and then he gets to the standard of review on appeal.
Thank you.
And that's the test that I articulated. And it's one that I think yesterday Mr. Matthews accepted. This is an applicable case. So I don't think there's a dispute between us. And it's consistent, as I said, with the navigator approach as to the nature of the contempt jurisdiction being quasi-criminal. I said I would then come back to the authorities on the approach to prior findings in this context. And first of all, there is the Al-Gabiri case. I don't think you need to turn that up, but it's an example where Mr. Justice Spencer had regard to previous findings of dishonesty when considering contempt, and the relevant paragraphs are paragraphs 38, 46, and 47, and that's in the bundle at authorities tab 35. The second authority I would like to show you, which is at tab 50 of the authorities bundle, and that's in your bundle 6. And this is the Helen or Bailey and Bailey case. And as I mentioned, the Court of Appeal has recently cited the decision of Mr. Justice Peel in the Manzi case with approval at paragraph 39 of the Manzi case. So, and that is, it's tab 53 at paragraph 59. It's W and A, rather, sorry, not Manzi, W and A. And the decision in Helen, we can see, was reached following detailed consideration of relevant authorities, and you see that at paragraphs 10 to 17 of the judgment. So by way of example, Abliazov was considered at paragraph 13, and various other authorities. And at paragraph 50 of the judgment, the judge explains his approach to prior findings and explains the reasons why he was placing weight on those findings. and I mentioned the Ablyazov case, which is cited at paragraph 13 of this judgment, because, of course, in that case, Sir Ross Cranston concluded that he could give considerable weight to the prior findings made by Mr Justice Tier. And just for your note, the Ablyazov decision is at the Authorities Bundle tab 26, and the relevant paragraph is 29. So what your Lordship can see is that there are a number of authorities which, although criticism was sought to be made in the skeleton of Mr Vik, I think Mr Matthews did not pursue that. And what you see is that there are a number of authorities on this very matter in the contempt cases, showing that the judges have had regard to the prior findings of the relevant trial judge, and Mr Vik hasn't engaged with, for example, the Ablyazov authority on that point. And it's clearly correct, because none of the arguments about different cases apply. These are all relating to the same subject matter. So one sees that this approach is perfectly acceptable, and the approach of Mr Justice Peel seems to be that obviously he had to be satisfied independently, which is precisely the approach that Mrs Justice Moulder took with the reality check, insofar as she did, which actually, as we'll come on to see, was in itself relatively limited.
Yes, what he actually says is entitled to take it into account as background material.
That's right.
That's the comparison you're drawing with Mrs Justice Moulder.
And that's what we say she did as well.
Yeah.
And if you have any doubt about that, I would recommend that you look at the transcript that I referred you to at the start of my submissions, because you'll see that Mrs Justice Moulder was actually quite tough about that. So she really did know the basis on which she was approaching the case. My Lord, the other reference, just for your note, is Mrs Justice Whipple's decision as she then was, in the Viz trading case. And that's in the Authorities Bundle at tab 32, paragraph 28. And she also referred to prior findings as supporting reality check on an independent finding she made. So we see a wealth of authority. I've dealt with that point because it was a point that's been made by my learned friend. But I don't think you need to turn it up, my Lord, unless you wish to.
Oh, well, I just did she actually use the word reality check?
No, I've used that as shorthand.
That's what I was looking to see.
I'm sorry, I've used that as shorthand. That's what I say she was doing.
Yeah,
having,
okay.
Gratefully adopted Mrs Justice Andrews, Lady Justice Andrews' wording. My Lord, I've dealt with that argument because it was put as a mainstay of the case against me. But in fact, the way the case developed and the submissions developed yesterday, there was a real inconsistency in Mr Vik's position. Because Mr Vik's position, as articulated yesterday at page 35 of the transcript, was actually that the problem was that the judge had given insufficient weight to other prior judicial findings, namely the Connecticut judgment. And yesterday there was something made of the fact that more weight should have been afforded, it is said, to that judgment because it arose from proceedings in which Deutsche Bank and Mr Vik were both parties, and that was at the transcript, day 1, page 28, line 25, to page 29, line 1. Now, again, this is not a point that was made in Mr Vik's skeleton, which refers to the Connecticut judgment only in passing, paragraph 24. But in any case, the point's a bad point for 4 reasons. First of all, the judge plainly did consider the Connecticut judgment because she concluded that she didn't need to rely on it to reach her findings, but nonetheless took it into account. And that's at paragraph 53 of the judgment. Secondly, as both my Lords, Lord Justice Mayles and Lord Justice Nugee noted yesterday, and for your references, that's the transcript at page 33 and page 49, no issue estoppel arises in relation to credibility. And the suggestion that the Connecticut judgment warrants greater weight for some reason was hard to follow in that context. In any event, Mr Vik gave evidence before Mr Justice Cook, and I've already made the point that he was treated as the real party behind the litigation, and it's therefore is hard to follow why the Connecticut judgment on credibility should be more relevant. The third point is that Mr Vik's real criticism seems to be not, as I say, that the judge placed limited weight, as she did, on the findings of Mr Justice Cook, but rather the judge didn't rely on the cherry-picked passages of the Connecticut judgment. So what his case actually is not that the judge was wrongly taking into account prior findings, but that the Connecticut judgment somehow trumped the judgment of Mr Justice Cook, but more fundamentally somehow trumped his own evidence given to Mrs Justice Moulder. That's essentially where he comes out, that if she had taken account of the Connecticut judgment, she would have reached a different conclusion. So one can immediately see the problem with his argument. And the fourth point is, in any case, the findings of Mr Justice Cook that Mrs Justice Moulder had regard to at paragraphs 327 and 328 of her judgment, the one example, in fact had nothing to do with the issues in the Connecticut judgment at all. So the attempt to say actually that was the more relevant judgment falls on that point as well. And I can make that good. I don't know the extent to which your Lordship is familiar with the Connecticut judgment and to what extent you have an appetite to go through it. But broadly, it was relating to a point that was not an issue before Mr Justice Cook, because it went to piercing the corporate veil and the relevant standard. So it didn't actually assist. It didn't undermine Mr Justice Cook's relevant findings in the trial judgment, and those were specifically paragraphs 343 to 386 of that judgment in the first tab of the authorities bundle. And in fact, key passages of the Connecticut judgment upheld, or I say upheld, agreed with Mr Justice Cook's findings, namely that Beatrice was in fact a company controlled by Mr Vik and he could move monies about as he saw fit. And it didn't exonerate him in quite the way that Mr Matthews would like to say. Now, I can take
Well, I think what was, at least what I understood from passages that we were shown, was that the Connecticut judgment didn't think that the transfer to Beatrice was asset stripping, because, or at least to avoid liability to Deutsche Bank, because something like $500 million was left.
And there was that was for a different purpose on a different test, we say. And there was undoubtedly, I'll show it to you, because it may be quick to look at the actual judgment. But the point is, first and foremost, you can't have it both ways. If you say the judge shouldn't be looking at prior findings and has been infected, you can't then say, but in fact, there was a different judgment you should have been infected by. And number two, it's not actually on point, so it's not right to say the judge should have taken more account of it than she did. But that's the bottom line. But if we could just have a look at the judgment, perhaps, and you'll see the point I'm making. It's at tab 7 of the authorities bundle, which will be your bundle 1.
I don't think it's in our bundle 1.
It's in bundle 2.
Oh, it's bundle 2, I'm sorry.
The whole of volume 1 is taken up with the first judgment, so.
Right.
Just the introduction to the first judgment.
Yes, some of the first judgment.
Some of the first judgment.
Well, it was a 14-week trial and I think, I'm sure your Lordship has appreciated this, but Mr Vik advanced an $8 billion claim
we know about that.
based upon a hypothetical portfolio. So that, I think at the time, was probably the largest claim that had been issued. And that's been superseded now, but at the time, Mr Justice Cook heard a lot of evidence on that.
Mm-hmm.
So, my Lord, you can see that this was a 5-day hearing, and the issue was, as you see, the plaintiff failed to satisfy its burden of proof to justify piercing the corporate veil, and that Mr Vik diverted SHI's assets with the specific intent of rendering it unable. So those were the questions. And what you can see is, starting at page 16, paragraph 40, the judge makes findings about what Mr Vik knew about the cash in SHI's accounts. And at paragraph 43, what else SHI had. And then at paragraph 44, on that basis, makes conclusions about what Mr Vik could reasonably have believed. And that went to the key issue in these proceedings of whether Mr Vik could have thought there was sufficient cash left in SHI to pay Deutsche Bank's margin calls. You then go over to page 19 at the bottom, SHI's asset transfers. And at page 23, paragraph 60, we see that Mr Vik testified that the transfers were his sole discretion. He said, that's where I wanted the money to go. And he moves them wherever, between his entities, whenever and however he saw fit. Now that's entirely consistent with Mr Justice Cook's findings that Mr Vik moved money from SHI to Beatrice as he saw fit. And that's paragraph 1453 of the trial judgment. And it also supports the bank's case that Mr Vik would have kept a close eye on what was in Beatrice and the trust, since it shows that these were effectively Mr Vik's own funds. Page 24, paragraph 65. Consistently with all the above, the paragraphs, the judge finds that Mr Vik instructed monies to be transferred from SHI's account to Beatrice's account. Mr Vik controlled both companies in arranging the transfer. Initially, it was characterised as a capital distribution, but was later characterised as a repayment of loans. Page 27, section K, which is 4 paragraphs up from the bottom, the court then reviews what happens when the bank sent the 5th and 6th margin calls to SHI and SHI didn't pay the 6th. And we see on page 29, at paragraph 92, that the bank realised on the 22nd of October 2008 that due to a system error, SHI was underwater by hundreds of millions of dollars. We then have paragraph 111 to 112 on page 33, which is a summary of the position, essentially concluding that on the basis of Mr Davis, that's the expert evidence of Mr Vik, and that was unrebutted, Mr Vik could have concluded that there were still sums in the account sufficient to meet the 6th margin call. And then we have at page 34 the discussion about the legal analysis of whether SHI was the alter ego of Mr Vik to pierce the corporate veil. And the burden of proof is stated at paragraph 45. I think Mr. Justice Nugee asked that question. Page 45. And then the judge's findings start on page 56 at section B, and we see paragraph 57, page 57, that Mr Vik completely dominated SHI. And then the third bullet, so that's, you can see that's the second paragraph from the top. He completely dominated and controlled SHI. And from the third bullet point up from the bottom, Mr Vik regularly transferred massive funds between Beatrice, another company controlled by him, and SHI. He did it without any formality, as if transferring money from one pocket to another. And it said, in fairness to Mr Vik, it was done often without documentation. And then page 58, first, the court considers the question of specific intent, which was key to the decision in this case. And then page 59, the third bullet, whilst Mr Vik testified to various rationalisations for SHI's October transfers, these explanations were formulated after the commencement of the litigation. The court finds none of these rationalisations to be credible. Mr Justice Cook was of the same opinion and stated in paragraph 1451 of the English judgment, and then it goes on, quoting Mr Justice Cook's conclusion that the version of events which he puts forward is not, to my mind, susceptible of belief. So you see, in fact, the Connecticut judge reached that same finding, and what he found at page 61 consistently with that, and it's the first bullet at the end, that Mr Vik was trying to preserve his wealth for the benefit of his family. So again, that's entirely consistent with the bank's case that Mr Vik must have kept a check on Beatrice and the trust's assets given the steps he was taking. And then what you see then at the bottom of page 62 is that the court nonetheless held that notwithstanding the transfers, Mr Vik left a large amount of money in his accounts at the bank, and that he could have reasonably believed that would have covered the 6th margin call. And he concludes on page 63 that the bank can't satisfy the burden of proof, and all the findings are made on the basis that Mr Vik's subjective motivation in making the transfers is irrelevant, and you see that on page 62. So what we can see from that is, for the purposes of the Beatrice arguments and so on, in fact, this judgment is entirely consistent with Mr Justice Cook's findings. It finds in favour of Mr Vik, no doubt. I don't shy away from that, but on a different issue with a different test. Mrs Justice Moulder was aware of this judgment, and there's no further weight that we can see that she could have placed on it, nor would it have changed her conclusions. But the very fact that my learned friend is so adamant that it was should have been given more weight, we say, undercuts his argument that it was wrong to look at the admissible findings in Mr Justice Cook.
And I suppose you say, do you, that so far as this judgment is relevant to Mr Vik's credibility, it didn't actually get a ringing endorsement from the Connecticut judge.
It didn't. And moreover, it didn't deal with Mr Justice Cook's findings that Mr Vik fabricated oral agreements and fabricated documents. The judgment doesn't touch on those points.
Right.
We then, on the prior findings, I also wanted to come back on, just so that Your Lordship had it, the conditions judgment. I showed you the judgment of Mr Justice Cook, which was relevant in the context of the costs order being made against Mr Vik as the real party, and the conditions that were attached to SHI's appeal. In tab 2 is the Court of Appeal's decision on an appeal from that decision. And that's a decision of Lord Justice Longmore and Lord Justice Tomlinson in 2014. And if you can just look at, from paragraph 6, they refer to the fact that Mr Justice Cook handed down his judgment. And at paragraph 8, the judge was very critical of Mr Vik. Just read that. I appreciate this is citing what Mr Justice Cook found. then if we go to paragraph 9, this notwithstanding, it's about 6 lines down, criticism was made first of the bank systems. This notwithstanding, taking all relevant factors into account, the judge nonetheless made an unequivocal finding that on or after the 13th of October 2008, when Mr Vik had a clear idea that SHI's trading liabilities ran to many millions of dollars, he caused just shy of $900 million to be transferred to him or companies closely associated with him, and then there's a reference made to Beatrice and the judge's finding. Go over the page, they then refer to the judgment I had just shown you, the non-party cost order judgment, where they refer to the decision made by Mr Justice Cook and the order he made in paragraph 11. And then we see the bank's application, paragraph 12, the application now before the court is the bank's application seeking an order from the court imposing conditions upon the pursuit by SHI of its application for permission to appeal. And you see the conditions the bank sought. And in answer to my Lord Justice Mayall's question, were there witness statements from Mr Vik, you can see here one's referred to in paragraph 14. So Mr Vik has continued to give witness statements. And his case was that SHI was unable to fund the payment into court. And
Yes,
then
I see. Actually, he also gave evidence in Connecticut.
Yes, he
I'd
did.
overlooked that.
My Lord, just to be clear, Mr Vik has given evidence not just in the Connecticut proceedings in this case, but we can check, I think, in other litigation,
Right.
not unrelated to the bank, or he's certainly been involved in it. He's not litigation averse. So, my Lord, paragraph 15, the court refers to Mr Vik's description of Beatrice as his savings company and the judge's finding. And in particular, the fact that the judge had found that an agreement made between Beatrice and SHI was a fabricated ex post facto. It's one of Mr Justice Cook's findings. And in 16, referred to the fact that SHI has not sought permission to appeal in respect of any of the judge's findings. And a letter is set out from Mr Vik in his capacity as director of SHI. And I think I'm not going to go over the binding debate again. My Lord Justice Nugee is right, but I had in mind, one of the points I had in mind was at the end of that extract, the reference by the Court of Appeal to Mr Vik's approach to the relative inviolability of these findings is realistic. And by that, he wasn't seeking to unravel. And they set out what Mr Vik did and said, and it was suggested in a witness statement of Mr Vik's then solicitors, Travis Smith, that there were reasons why they hadn't appealed those findings, but the Court of Appeal don't accept that and say it's in 19, it's therefore a telling feature of this litigation that SHI has not sought to appeal these damning findings. And paragraph 20, in opposition to this application, however, SHI seeks to re-argue its case. Well, that has been a pattern throughout, and it's recorded here. And here, you see the court refers to the new evidence in the shape of witness statements from Mr Vik and Mr Johansson, and upon documents recently created either by itself or by third parties, which it is said evidence alone is asserted at trial, and it refers to the new evidence. And you see that Mr Foxton, QC as he then was my leader, referred to the reasons why that evidence was not susceptible of belief, and the court concludes that all the evidence was available to Mr Justice Cook on the Section 51 application. And of course, this was when the sale agreement was also produced. And then if we could go to paragraph 26 of the judgment, I've already indicated that I accept it as inherent or implicit in the judge's findings that as at October 2008, SHI had the right to recover its funds. It's not asserted that the ability to recover the funds has been lost in consequence of subsequent transactions in the ordinary course of business. And if the court could read on to paragraph 27, I also note that SHI is careful not to suggest in its evidence that there is any reason to believe Mr Vik would not be able to fund any payment imposed as a condition of the pursuit of the application for permission to appeal. Which, of course, I think is what happens because the conditions are imposed. And you see at paragraph 36, it's right to point out that Mr Vik gave no guarantee for the liabilities of SHI to DB, and that is a point which he's entitled to stress and does stress. However, there's no evidence to suggest that Mr Vik is not still the sole owner and director of SHI as he was in 2008. Given the judge's findings as to the manner in which Mr Vik treated SHI, it's difficult to think there could be a more appropriate case in which to take into account that he could, if minded to do so, pay the judgment debt. It's not necessary to go that far. On the basis on which I approached the case, SHI could itself pay the judgment debt into court if Mr Vik chose to procure it to do so. That does not involve Mr Vik funding SHI or paying the judgment debt on its behalf. It involves Mr Vik taking steps to restore to SHI what are rightfully its assets. And there are other judgments to that effect. Indeed, Mr Justice Tier referred to Mr Vik as a man who would essentially do anything to avoid paying the debt. What he said is, so the fact is that what's clear is that it's been found, we say repeatedly on an admissible basis, that Mr Vik would have been able to restore monies to SHI because of his relationship with SHI and indeed Beatrice. And that is the context in which the Part 71 order came to be made and Mr Vik gave evidence. And it's also relevant when you're considering the judge's approach to the evidence given and some of the criticisms made, that when considering what Mr Vik understood, and one of the submissions that's been made against me is that there has to be some objective construction of the questions. So that's not right. What we're looking at here is a man who's given evidence throughout, in all that context, and knew, obviously, given that context and the evidence he'd served, that the bank wanted to find out a simple question of what had happened to the money. Can I then move on to the other point taken on credibility, which was a point on fairness and abandoned allegations? I think this is the second heading of my learned friend's criticisms.
Yes.
Now, in a nutshell, we say there was nothing unfair about questioning Mr Vik in connection with the Carlisle transfer deeds, which I think was the real nub of this criticism. The bank's case was that Mr Vik had sought to mislead through his disclosure of the Carlisle deeds, and that case was not abandoned. It formed part of the matters relied upon in support of the bank's case that Mr Vik had given defective disclosure of electronic documents relating to the partnership deeds by suppressing material, which later it turned out we were right, it came to light. And if we can look at, please, the core bundle tab 11, this was the bank's Part 81 application notice as amended. And we say that we list the contempts, and it's at little b on page 306, he fails to produce the documents, and you see little 1, responsive to the Tier J order, in particular electronic documents, A relating to the Devon Park interest, B relating to IFA shares, C relating to SHI's interest in the partnerships. And the basis for the allegation that Mr Vik had sought to mislead through the disclosure of what he disclosed without disclosing anything else was set out in detail in Mr Hart's first statement, which, if I can just remind your Lordship, is in the supplemental bundle 2, and it's tab 12 at page 418. Case is set out in detail and tied into the terms of the order we say were breached. Now, that was served nearly 3 years in advance of the hearing before Mrs Justice Moulder. And those paragraphs of evidence were never withdrawn. They remain part of the evidence at the committal hearing, as did all the copies of the transfer deeds and other relevant contemporaneous documents which were included in the exhibit to Part 1. And no application was made by Mr Vik to strike through the relevant paragraphs of the witness statement or take the supporting documents in the exhibit out of the bundle, despite Mr Vik taking objections to other material. And the detailed explanation given in Part 1 was explicitly cross-referenced and relied upon in the parts of Part 1 that specifically address the pursued allegation of non-disclosure. So the best example is at paragraph 235. And that is, sorry, 237, which is at page 434. And that paragraph and paragraph 235, which I don't think is in the bundle, were both referenced in support of the allegation of non-disclosure in the bank's schedule. So if we just go back to the core bundle, that's at tab 11, page 313. It's 11A2. And just to tell your Lordship the context of this, the position was that Mr Vik complained that he didn't understand the case that he had to meet because Mr Hart had served such a long affidavit. And it was said that the application notice for contempt should have contained all the material just in it without having the evidence. And on that basis, he tried to strike out the application for contempt. And that's just the final judgment I'm just going to show you to make that good, which is in, I think, your bundle 2. And it's the judgment of Mrs Justice Cockerell. Hearing that ultimately took 3 days. You can see that from paragraph 1, in part because of adjournment. And in consequence of some of the complaints made, the committal application was amended. So the chronology is Mr Justice Tier said in relation to the then upcoming committal hearing, essentially has an eye to proportionality. The bank slimmed down, having an eye to proportionality, amended, and also tried to ensure, in response to the criticisms, that everything was clear. And Mr Vik then cross-applied and the hearing, I think, ended up being either in or close to the window for the original contempt hearing, and sought to strike it out on the grounds that it lacked particularity. And there's no need to go through the whole of it, but what you can see is any complaint that Mr Vik didn't understand what the complaint was against him was dismissed by the judge. And if you can look at, for example, paragraph 108 and 109 of the judgment, and also if you could look at 101 to 103. And essentially what the judge says is you can't say that the bank must, this is relevant on the sale agreement, which I'm going to come on to, you can't keep saying that the bank has to provide particulars of what Mr Vik did. The bank won't necessarily know. And in particular, if you look at paragraph 128, it was said, I think, on passant this morning that the case on Universal wasn't clear by Mr Matthews. Well, that complaint was made before Mrs Justice Cockerell and rejected, and you see that in paragraph 128. So, what wasn't said to Mrs Justice Cockerell is, why is all the evidence about the Carlisle transfers still in the witness statement? That complaint was not made, notwithstanding pretty much everything else seems to have been. And what's clear is it's not right, as Mr Matthews kept saying, that it was going to, there's no allegation of contempt to which it was relevant to. It clearly was relevant, and it was referenced in the application notice and in the evidence in that way. Mr Vik was then cross-examined both at the Part 71 hearing about it and then in detail at the Committal hearing about it. And he was absolutely not taken by surprise. The case was fairly and squarely put to him. For example, it was put to him repeatedly that he was lying about it, and the references are transcript day 7, pages 93 to 94. And that's in the core supplemental bundle at tab 44. And the judge also asked me to put follow-up questions, which I did, and you can see that at page 95 of the same reference. And there was no suggestion Mr Vik was unable to deal with it. The judge noted, as you will have seen, that Mr Vik was fully able to deal with cross-examination, and indeed regarded it, and I'm paraphrasing, as something of a game. Now, that it's the third time he's been cross-examined in the litigation about SHI, and the second time, therefore, he's been cross-examined about the Carlisle deeds. And the relevant deeds were not shown one after the other, which I think was said by Mr Matthews, but they were, in fact, displayed side by side on a split screen. And you can see that on the transcript at page 78 of, I think it's day 7. So it's not right, as it was said, that he was in any way confused about it. He and the judge were shown both. And we cannot find, but Mr Matthews may have a better reference, that any objection was raised to the questioning on the Carlisle deeds. Now, it was said there was. That was yesterday, page 108 of the transcript.
Well, I think Mr Matthews did get up at some point and say, I have a concern as to where this is going, but it wasn't really pursued.
And what the cross-examination was, it was in relation to Mr Vik's misleading disclosure, and that started just before lunch on day 7, and that's page 65 of day 7's transcript, and it continued to page 94, so it's page 65 to 94, with no objection. An objection was raised when I put to Mr Vik that he had stripped assets from SHI, and the basis of the objection was that the prior questioning on disclosure was legitimate, but the next question I'd asked went directly to the abandoned allegation, and that objection was accepted and the questioning continued on the topic of non-disclosure. And you can see that, so the two relevant passages are day 7, page 65 to 94, and then day 7, page 94 to 100, and that's in the first supplemental bundle, tab 5, at page 197 to 206.
Yes, the intervention I had in mind was at page 95.
Yeah, exactly. I made the point already, he obviously wasn't re-examined, and he didn't address the case that he'd given misleading disclosure in either his written or oral closing submissions. Just by way of background, it was also accepted yesterday that Mr Vik had addressed the abandoned allegation in his original affidavit, which was withdrawn following the amendment application, but it follows that he had considered the original allegation in advance of the hearing.
And your side had seen that.
So what we say is it's not, there's no question about fairness here, and that point falls away when you see the facts. In any case, as my Lord Justice Nugee said, to the extent the questioning went to credibility, and on this ground at the moment of objection, that's the complaint, the bank had no obligation to plead or give Mr Vik advance notice of the questioning, albeit in fact we did through Mr Hart's first affidavit. And the time to take any sort of objection in that regard would have been below, and it's too late to do so now. So can I just make good those 2 points? I think my Lord Justice Nugee was inquiring whether there was an authority on the point yesterday, and it's one in the bundle. It's the Hobbs case. It's at the authorities 8, which must be in your bundle 2, at pages 18 to 19, and goes to the point that matters of credibility do not need to be pleaded to form the basis of cross-examination.
I always thought it was not only do not need to be, but should not be.
Should not be.
Yeah, well, quite. So it's quite clear that there was no reason to go down that route. And then it's the Hawksworth case, which is tab 24, paragraphs 40 to 42, which holds that a complaint that a party raised an unpleaded matter should be taken at the time and a ruling from the trial judge sought, and that it's too late to raise a complaint for the first time on appeal. Just to cover this off, it seemed to be suggested on behalf of Mr Vik, this was yesterday, page 107, lines 20 to 24, that pleading requirements for committal applications were more onerous than those for civil proceedings. And we say that's clearly wrong, and if you need an authority for that, it's the business mortgage case at tab 54 of the authorities Authorities Bundle, paragraph 89. We say that in fact the opposite is true. As Mrs. Justice Cockerell found, what's required are brief details sufficient for the contempt law to understand the substance of the charge against him. So all of the lead-in to this point, we say, is completely wrong. There's no basis on which to say it was unfair or it was not open for the bank to cross-examine as it did. In any case, be that as it may, the judge's treatment of Mr Vik's evidence on this point was entirely fair. Because, first of all, the judge was alive to the fact that the bank had discontinued the allegations of false oral evidence and explicitly took that into account. And you see that in paragraphs 79, 95 and 113 little Roman 6 of her judgment. Second, and crucially, and this is coming on to, I think, the point that I was articulating this morning when my Lord Justice Mayors asked, the judge's findings on this issue form just one of many reasons relied on the judge for her conclusion that Mr Vik lacked credibility. And the attempt in oral submissions yesterday to present the judge's findings on this issue as the sole basis of her findings, or the key basis of her findings on general credibility, we say is not sustainable. And it may be for this worth having the judge's judgment to hand. So, if we could go to page 193, which is paragraph 54. So, the judge gave in the passage from paragraph 54 through to 75, so over multiple pages of her judgment, a number of examples of Mr Vik's obfuscation under cross-examination when he disingenuously pretended not to recall events or documents with which he was familiar, or he pretended not to understand questions. And it's clear that all of that fed into, and she says so, her assessment of his general credibility. A key one, which we'll come on to being at paragraph 78. So as well as those examples, there were three other examples in the next section, 76 to 85, of Mr Vik telling lies during his evidence. His evidence being described variously by the judge as absurd, clearly a lie, and wholly incredible. And, for example, paragraph 78, where Mr Vik tried to interpret an email from Mr Johansson, where he said in terms he was the manager of the asset. And Mr Vik tried to say that that should be interpreted as Mr Johansson talking about the management of time. So he says, the words he says were, as any good manager was, and that was in the context of dealing with an asset. And Mr Vik says, the words, as any good manager would, was management of time. And one can see it's only at 79 when she refers to the partnership when giving all these various examples. The judge also found that Mr Vik's own evidence suggested that he was a man who demonstrated a readiness not to tell the truth in his business dealings. And he said he paid no attention to documents he signed, and that was at the judgment in paragraphs 99 to 100. And indeed, just to make good a point I mentioned this morning, so serious were Mr Vik's misrepresentations in documents signed by him that Mr Matthews was forced to concede in his oral closing submissions that it was entirely possible that Mr Vik has signed documents that did not accurately represent the position towards the tax authorities. And that was on the transcript, day 10, page 77, line 11 to 14. That's core supplemental tab 8, page 66. The next point the judge had in mind was that in general, as she held it in her judgment at paragraph 101, Mr Vik appeared to regard cross-examination as an intellectual challenge to pit himself against counsel for the bank. So what we see is a whole section where she basically says, here are the examples in which I think he's dishonest, here are the lies he's told, and this is the general, more generally informing her view. So the suggestion that the one point that Mr Matthews has yesterday honed in on, which we'll come on to, the execution twice point, was the mainstay of the judge's findings and tainted it, is just not sustainable on the face of the judgment itself. In any case, and this is my third point on the topic, the judge made multiple independent findings throughout the judgment that further specific parts of Mr Vik's evidence were not credible. And can I give you some references? That's paragraphs 135, 146, 186, 307, 321, 372, 435 and 446. So when the judge made reference in the judgment to Mr Vik's credibility, there's no reason to read that as not including all of her findings, general in this section, and all of the specific findings she made, which formed part of her overall assessment of his credibility in the round, as she put it at paragraph 52 of her judgment. The fourth point is that on each occasion identified in Mr Vik's oral submissions, this was yesterday, page 114 of the transcript, as one in which the judge referred to Mr Vik's general credibility as relevant to a specific finding of fact, the judge identified other, and in some cases many other, reasons for finding Mr Vik's evidence on that specific issue to be untrue or incredible. So take, for example, paragraph 190. That's an example. Similarly, paragraph 265. And the other references are 307, 326, 415 to 417. So it follows from all of that that whilst the judge regarded her findings on the Carlisle deeds as highly relevant, her words at paragraph 95, they ultimately, plainly on the face of her judgment, form just one part of her general assessment of the credibility of Mr Vik, and she had regard to many other compelling examples, entitling her to conclude that he was not a truthful witness. And just standing back...
Well, it was one of her building blocks, and the difficulty is we don't know whether the structure would have come falling down if that one had been pulled out.
Well, I think we do, my lord, because all the examples I've given you show, so starting with paragraph 52, that she didn't regard herself as resting on any one finding. So we do know it wouldn't have come down as a structure. She says, although I consider below the individual allegations of contempt, it's appropriate and important to form a view on his evidence in the round, and in particular to assist in determining what weight the court should give to his evidence. So she says, essentially, I'm not looking at any one thing by itself. I will go through the specific allegations of contempt, which she does incredibly well. but she looks at all of his evidence. So we do know, because she said so, that no one piece of evidence was the evidence that she regarded as crucial. And indeed, had it been, and given that this is the mainstay of my learned friend's new case, you would have to have in terms evidence on the face of the judgment that she regarded this as the mainstay. And there is no such evidence. She says it's highly relevant. And what I want to address you on, but I think in fairness to the bank, we do need time to look at the submission that's been put in to tell you why it's wrong. I mean, we're pretty clear it's wrong, but I want to be able to give you chapter and verse on it. But what we would say is what she regarded as highly relevant in any case is clear. It's not the fact that Mr Vik may or may not have signed the Doc 2Ds. It's the fact that there were these Ds that for which there was no explanation as to what the justification was for A, the backdated date, and B, the suppression of the executed version and the absence of a proper explanation. So that's what's highly relevant, not the point that my learned friend has honed in on. And in any case, the learned judge cannot be taken to have found that as the mainstay because she says she found so many other things relevant. And just standing back, if
well, Mr. Matthews says, so far as suppression of the executed version is concerned, in effect, these are not his words, but that there's no paper trail linking Mr. Vik to those, to which you would say what?
To which we would say that Mr. Vik disclosed out of the ether in advance of the Part 71 order, responsively, a deed which his solicitors had previously claimed on his instructions that they had no documents. He didn't explain how it had come about. He didn't disclose anything else. And then a Norwich Pharmacal led to the disclosure of executed versions. And one would have expected, if Mr. Matthews is right, an explanation when he was asked about it as to how that came about. And he was asked about the Carlisle deeds in 2015, and then he was asked again in 2022. So he had plenty of time to work out what had gone wrong, but he gave no explanation. So Mr. Matthews saying, oh, we can't trace it to him, well, there are 2 points. One is that an honest person would have had an explanation. I mean, these are his documents, and don't forget, my lord, the context. I'll deal with this in more detail tomorrow, but the context of this is vital. This is why it's so important one understands it. Mr. Vik's case was that he hadn't been guilty of asset stripping of these assets because the transfer had been executed on the 30th of September 2008. In fact, the banks realised from the publications in the London Gazette that the transfers were recorded as having taken place in much later, in that 2009. And Mr. Vik produced, as an explanation, these deeds before the Part 71 hearing, his solicitors having said no documents existed. And then, through the Norwich Pharmacal, it turns out that the documents he presented as supporting that 2008 case were never executed and were highly misleading, because when you see, and I'll take you through this tomorrow, when you see the documents, what you can see is that the actual executed documents were completely different and had different text in it, as well as different dates. And I think one of the questions that may have been asked by my Lord Justice Nugee or Lady Justice Andrews, I can't remember, I'm afraid, was about drafts. Well, in fact, and because the point was sprung yesterday, it wasn't entirely clear, but you've seen it now, as Mr. Hart's statement makes clear, when the Carlisle partnerships produced the executed versions under the Norwich Pharmacal, the bank then contacted them to ask whether there were drafts, because was it possible that there'd been a previous draft? And they sent over their drafts, which had typewritten in, so nothing like the manuscript version Mr. Vik had disclosed, with a February date. So, 2009. So what one can see is that the Carlisle Partnership track record of the documents was of documents that were typed up and completely different. And the ones disclosed...
And that provides, or may provide, a basis for the judge saying no, not the two signing, but saying that the documents were amended,
yes,
which was puzzling me yesterday.
That is the
but
reason.
I wasn't then aware that there were these typed versions of, typed date versions of version 5.
That's right. I will show you all these tomorrow. The reason I'm not doing it now, I can do it now, but I'd have to reserve the right to come back on
Do it once
taken.
when you're ready.
Yes,
do it
but the fact is that there is an explanation, clear explanation for the judge, A, saying they'd been amended because they had, B, there is an explanation for the two signing, but it's right to say I didn't put that question, and C, the clear nub of it is that the judge was right and the bank's right, that there's something about this that's dodgy, and nothing Mr Vik has said explains it. Indeed, his best case before the judge was, the tax authorities were misled. That's the type of argument he makes. There's no real explanation of these documents as to why this would exist. But I'll come back to this tomorrow. But the point is that the judge was aware of this. There's no reason to hone in on the two signing point and say, right, that unravels the entire judgment. And just standing back, if you strip out paragraph 95 and the findings about the Carlisle deeds, you're left with a judgment that just goes through, A, multiple reasons why she found Mr Vik to be dishonest generally, and then individual allegations of contempt, all of which she found against him on the specific evidence. So, putting it that way, there's no way that this one point would unravel the judgment, because even if you stripped it out, the judgment would stand. But as it turns out, there are, I don't think Mr Matthews has identified anything that would have changed her judgment on this, because it's clear that she regarded it as highly suspicious. And whatever Mr Matthews says now doesn't answer it. But also, the second point I was going to make, so there were 2 points, was that if Mr Matthews had advanced this case below in any way, I know he says it all comes from the judge's misunderstanding of this one point, but clearly the point was being made that this deed was misleading. But he didn't. I didn't cross-examine Mr Vik beyond the material I had. Didn't know if they weren't advancing a positive case to this extent. And he didn't address it in his submissions. So all we can say is we gave Mr Vik every opportunity to explain it, and he didn't. And nothing Mr Matthews has said now gives an explanation. So, my lord, is that a convenient moment, or would you like me to finish one more head?
Do one more head.
So, I think we're on the third limb now, which is Mr Vik's remaining criticisms on credibility. So, he identifies a number of alleged errors that the judge made in evaluating Mr Vik's credibility, and each complaint essentially boils down to a discrete finding that Mr Vik is trying to overturn. And we say, as a matter of approach, that's not permissible, because none of them establish an error on the judge's part. It's just that Mr Vik says she should have reached a different conclusion. So starting with, first of all, the assessment of the evidence concerning the provisions of the Beatrice Trust Deed. That's Mr Vik's skeleton at paragraph 71. And no misunderstanding is apparent on the part of the judge. The judge's finding was that there was a clear inconsistency in Mr Vik's evidence on this issue, and that's the judgment at 66 to 68. That's correct. At the committal hearing, Mr Vik's evidence was that he was unfamiliar with even the key terms of the trust deed, and the reference to that is pages 21 to 24 of his evidence, which is at Supplemental Bundle 1, tab 6, page 235. But the judge contrasted that with the Part 71 hearing, where Mr Vik's evidence was that he was generally familiar with the trustee terms, but hadn't looked at it in years. And that was at Supplemental Bundle 1, Tab 1, page 9. And the judge said that his attempted explanation for the inconsistency, i.e. that he is not a lawyer, was not plausible because he was a highly intelligent, sophisticated individual. Now, Mr Vik's latest explanation in paragraph 71(4) of his skeleton is that the inconsistency can be explained on the grounds that his memory had deteriorated, or might have deteriorated. But that's not remotely credible when you consider the purpose of the committal hearing and just how fundamental Beatrice and the trust was to the issues that he was going to be cross-examined on. It's also not realistic given he settled the trust and all the matters I'm going to come on to about his proximity to an interest in the trust. It's just inconceivable.
Well, the judge also wasn't impressed with the "I've forgotten" line of defence.
No, because when it suited him, he selectively remembered, and when it didn't, he didn't. The second point is that Mr Vik contends that the judge drew the wrong conclusion from 2 points arising in cross-examination. The first was his apparent inability to recall provisions of the trust deed, and the second was his inability to, his ability, when it helped him, to identify a helpful part of his wife's deposition transcript from memory. And the judge says and Mr Vik says it's not fair that he's been found by the judge to be playing effectively. The fact is, the judge found at paragraph 70 to 71 that his approach to the deposition showed that Mr Vik was already up to speed on the relevant documents. And she was right to think that, and no doubt that was in the round of his familiarity with all the litigation and the history and the relevance of the trust deed, and the fact that he had come to give evidence for several days on the topics that he'd been cross-examined on at the Part 71 hearing with the sanction of a prison sentence. So the idea that he didn't recall the trust deed in those circumstances was plainly self-serving. And what she said was, instead of just saying that, she could have done, she actually said, well, here's an example of why it doesn't make sense that he doesn't remember the trust deed, because here's an example of something that he was really up to speed on. Third, Mr Vik repeatedly claimed during the committal hearing he wasn't following the Part 71 hearing transcript. And the judge held that that was an obfuscation. Now, it said that the judge shouldn't have made that finding, but the judge was entirely entitled and well placed to make that finding. And can I just give you examples of his behaviour at numerous points during the cross-examination? I don't suggest we look at them all. But the best example of his obfuscation behaviour was in the core supplemental bundle, tab 6, page 55, pages 72 to 73. He also accepted he'd read the Part 71 transcript many times at core supplemental, tab 6, pages 54 to 56. That's page 67 of that transcript. And the other pages within that transcript at tab 6 to look at page 68, 69 and 71. There are more, but I won't give you them all. There are more examples. But the idea he couldn't remember the Part 71 transcript was plainly wrong, and particularly, again, given what he was there to do. And bear in mind, he said it wasn't clear that Mr Vik was going to deploy his evidence and then give oral evidence. And he chose to do that. So he obviously made the decision to come to court and to explain the position at the Part 71 in his answers and why it wasn't right. So the idea he didn't remember a transcript of only one day or hadn't familiarised himself with it is incredible, and the judge was right to find that. The next suggestion in his skeleton is that, in the same section, is that the difficulty could have been explained by struggles with a small screen and connection difficulties. And the reality is, he chose to give evidence remotely the minute he suggested that he couldn't understand something because of that connection. The hearing was adjourned, and it was quite clear that he was following everything and answering the questions. And an example of that is in the core supplemental bundle, tab 3 at page 20, and it's pages 2 to 3. In any case, standing back from all those complaints, it goes back to my original point, which is that this court can't criticise the judge for those findings. The fact is the judge heard his evidence, formed an impression of him, and concluded that he was somebody who obfuscated and gave convenient answers when it suited him. And she was well placed and entitled to do that. This court hasn't seen Mr Vik and can't challenge that, and these are not findings given that the judge gave specific examples. These are not findings that no reasonable judge could have found. And Mr Vik's case doesn't engage with that test. Finally, under this head, Mr Vik complains that the judge wrongly inferred that he was obfuscating when he said he couldn't answer questions about Devon Park. Now, that one's a plain misrepresentation of the judge's finding. And if we look at paragraph 74 of the judgment, what you see here is that he was asked why he expected Devon Park to respond to his request with potentially confidential information. Now, that was a matter within his own knowledge. He was not, as he suggests now, being asked to opine on the intentions of a third party, i.e. what Devon Park thought. He was asked what he thought. So the criticism made in the skeleton is not right. The judge was entitled to think that he could have answered the question as to what he himself expected. So for all those reasons, we say, standing back, Mr Vik doesn't engage with the test, which would knock out most of this anyway, that the judge clearly was entitled to have regard to prior findings as context, reality check as she did, and there's no example, bar one, of her actually referring to a finding, and even then, that one example shows that what she did was regarded as corroborating, not as basing her own finding upon. In any case, that argument's undercut by Mr Matthews' alternative case that what she should have done is looked at the Connecticut judgment. The Connecticut judgment itself rather supports the bank's case. There was no unfairness over the examination of the Carlisle deeds and cross-examination for all the reasons you've seen, and the judge's finding on that basis was not the only and central building block. In fact, it's not even clear it was a building block at all. It was a factor, relevant factor, but a factor. And finally, the last sort of range of complaints, none of which can be taken terribly seriously, don't demonstrate any misapproach on the judge's part. She justified all of them, and they're right. So that's credibility. I've got to come back to the new case on its specifics, which I'll do.
Yes.
But that's...
All right, well, do that tomorrow when you've got all your tackle in order. All right, well, we'll take 5 minutes now, shall we?
hear?
Yeah, you know.
I'm not growing. I am shouting a bit more though.
The colour stealing.
She could probably be working all night for the last 3 nights. She wasn't able to do it again.
Courts rise.
Yes, what next?
Beatrice, we're moving on to now the specific complaints. So grounds 5 and 6, which is Mr Matthew Skeleton 74 to 126 and our Skeleton argument at 87 to 133. So your Lordship will have seen that the judge found at paragraphs 202 to 204 that Mr Vik lied at the Part 71 hearing when he denied knowing what assets were in Beatrice in the trust as at August 2015 when he resigned as the trust cost protector and December 2015 at the date of the Part 71 hearing. Now the starting point is that these were plainly findings the judge was entitled to make. The evidence showed that Mr Vik had transferred $730 million of assets from SHI into Beatrice and the Trust in 2008 for no consideration. He then appointed, first as settler and then using his powers as the trust protector, trustees who had no knowledge of the affairs of Beatrice or the trust. And it followed for this and many other reasons that he must have kept a close eye on the affairs of the trust and Beatrice, because, not least, none of the trustees he appointed appeared to be or were capable of doing so, and also he had a real interest in the assets there, which was the inheritance of his children, he said. Now, the judge carefully analysed the relevant evidence over 24 pages of her judgment, starting at paragraph 117 on page 209. And it's important to have in mind the judge's approach, because when you look at these specific examples of how the judge approached it, it completely destroys, even if I haven't already, the arguments that were made about the judge's approach to Mr Vik and credibility and so on. Because what you see is that in each allegation of contempt, she goes through it at length, in detail, and examines the specific evidence and reaches her conclusion on that evidence. And she made findings, as she was entitled to do, on the evidence. First, that Mr Vik must have continued to keep a close check on the assets of Beatrice and the trust. That's 165 of her judgment. Second, that he knew what was in Beatrice and the trust both in August 2015 and December 2015. That's 196 of her judgment. And third, that he had given deliberately false evidence at the Part 71 hearing by his denials that he knew what the assets were in Beatrice and the trust at those times. That's 203 to 204, as I've shown you. There was substantial evidence in support of those findings, and her findings, as she sets out very diligently, were based on the evidence. We set that out at paragraphs 118 to 132 of our skeleton. And can I just outline briefly some of the key points? That starting in mid-October 2008, Mr Vik procured SHI to transfer the liquid assets for no consideration to Beatrice. Beatrice, like SHI, was a creature company of Mr Vik. He was its sole director and controller. His evidence was that he treated Beatrice as his personal savings company. And by October 2008, he had become aware of SHI's liabilities and entered the series of asset transfers that you've seen. In late 2008, in October, he settled the shares of Beatrice into the trust, which was the initials of which are his children. That's the CSCSME. And this is, that is his own evidence at paragraph 30 of his affidavit, which is in the core supplemental bundle at tab 13, page 94. The trust deed was not disclosed until October 2015. This was after Mr Vik had allegedly resigned as protector, which was in August 2015, but before the Part 71 hearing. And you see that in the judgment at paragraph 118, little Roman 10. Mr Vik's evidence at the committal trial was that he allegedly resigned because he was retiring or some other reason, but he casually disclosed his resignation for the first time during the Part 71 hearing. That was the first time it was mentioned. Now, the trust, I think it's common ground that Mr Vik says it was settled for the inheritance of his children, but its terms are very material. It shows from the outset that he retained extensive powers both as settler and as protector, and the suggestion that it was all delegated to the trustee and he had some nuclear power was spin with respect, and it may be worth just looking at that. So if we go to the core supplemental bundle at tab 22, can I just mention that rather irritatingly, the core supplemental bundle has some of, but not the whole of the trust deed, and the whole of the trust deed is in supplemental bundle 3 at tab 2022 as well as it. So
Which would you like us to look at?
I am using at the moment, if I don't mind, which I don't know if you've marked up a version. I've been using the core supplemental bundle, which has the main provisions in, but
All right.
I just wanted to mention that to you.
Okay, thank you.
So you see the heading of the name of the trust, and you see that Mr Vik is the grantor and that his wife and daughter are the non-independent trustees. And what you see in paragraph Article 2 is that the grantor's power, i.e. Mr Vik's power, is the trust is entirely revocable. The grantor shall have the right to alter, amend, revoke or terminate the trust in whole or in part. You then have that Article 2.2 that his wife shall have the power to revest absolutely in Mr Vik. In Article 3.1, the trust shall hold the trust property for the benefit of the grantor's descendants. And if you go to the end of that first sentence, as the trustees shall determine in their absolute discretion with the prior written consent of the grantor. Now, the passage that Mr Matthews relies on is the end of that provision. The trust shall be administered by the trustees in their absolute discretion. But that doesn't take away from the fact that ultimately this is Mr Vik's trust to do what he likes with from the provisions I've just shown you.
Well, that doesn't, as a matter of construction, give him power to dictate to a trustees
No,
what to do.
it doesn't.
It gives him a veto.
It does. But it also, if you read it though, going back to Article 2, the trust indenture is revocable and the grantor shall have the right to alter, amend, revoke
Yes.
or terminate. So that, in a way, could override any decision if he chose to do so. You then have Article 5.3, that he is then appoint the grantor as the protector. And we'll come back to that provision because obviously that has a significance. You then have Article 8.2. I just invite you to read that because the suggestion that it was common ground in some way that the assets were all cash or low risk isn't borne out by what investments there could be in the property. The judge had regard to that point. I think I remember her raising the point about strips and straddles not exactly being low risk.
Well, the fact that there's the power to invest in all of these sorts of things, including commodity futures and margin, doesn't mean to say that that's what the assets were. So we've got to be a bit careful, haven't we? About
Well, there are 2 points I leave. The first is I don't think it's common ground, as it was sort of presented, that the reason why you could have anybody as a trustee is because it was only cash and straightforward assets. We just don't know that.
No.
But the second point is, given that was a possibility,
Yes.
you would expect to have some trustees with some serious financial acumen. So you can't just assume, given that they had the power. So put it another way, if Mr Vik's case is right, that the trustees could do what they liked, and one of their powers was to invest in any of these instruments, then he can't have it both ways, because you would expect him to have somebody who was capable of making decisions about it.
And I suppose even if the assets were being managed by HSBC or any other independent person, one might expect that if this was an inheritance for Mr Vik's descendants, he would be jolly interested in making sure that they hadn't put the whole lot into commodity futures. I don't profess to know what a strip or a straddle is, but even discarding those, there are some quite risky things in here.
That's right. And so, given that the trustees, he said, would be able to do what they wanted, you would expect him to want to know what they were doing. And it was not no money. You've then got...
well, even without that, though, Mr. Loney, if you're the protector of the trust and one of your powers is to remove the trustees if they're up to no good, you've got to know what they're doing in order to be able to exercise it.
Exactly. So there are also... The other point I'm going to come on to is, of course, when the trustees say they know nothing about the trust. That's the second point, but yes, you would expect to know what the trustees were doing. You've then got Article 10, Article Roman 11. Now, this is the one that I'm just checking whether it's... So I'm sorry about this. This is in Supplemental Bundle 3. Maybe we can transfer this into the core.
Yes, that's a good idea.
Rather irritating otherwise. It's page 705 of tab 22. And it's Article 11, second sentence.
It's usually disaster when I start transferring pages, but I'll take a chance.
So it starts, my lord, notwithstanding the foregoing. So this is the limitation of powers on the grantor of the substitute property. But notwithstanding the foregoing, the grantor may at any time and from time to time, and without the consent of any of the trustees, and in a non-fiduciary capacity, acquire all or any portion of the trust property by substituting other property, or relinquish or renounce the power. So precisely, my lord, all three of your lordship and ladyship have said both yesterday and today, all of these powers presuppose oversight of the affairs of the trust and by extension Beatrice. Now, the judge went through these provisions. She also looked at who the trustees were, and the trustees were initially Mr Vik's wife and daughter, and they were later in 2013 replaced by an employee of Mr Vik's hotel company, Mr Brocken, who was in turn in 2016 replaced by a junior legal assistant at a Dominican Republic law firm called Mr Gonell. And that was all recorded in the judge's judgment at paragraph 118, little Roman 9. Now, the striking thing which the judge had regard to was that none of these trustees had material knowledge of the trustees' activities or assets or expertise. So if we could just go to Mrs Vik's deposition, which is at core supplemental tab 34.
Is that the one we looked at before? Where she said she didn't know anything about anything?
That's right. So maybe my lord, you don't need to look at it again, but she says she doesn't know anything about anything, is a fair summary. And that's from July 2015. Actually, we say it's the same one. Can I just check that? I think the one that my learned friend showed you was about her saying the...
there was one saying she didn't want to provide documents.
Exactly. And there was one saying about something about HSBC. This one, I think it's maybe just worth checking.
Right, sorry, what was the reference again
It's
then?
tab 34 at page 270
Of the core supplementary.
of the core supplementary.
I think we did look at this.
You did, right. It's lines 5 to 18.
She doesn't know what the assets of Beatrice are.
Yeah. And she doesn't have any understanding of what the business of Beatrice is.
I think we looked at it somewhere else. It's familiar, but I'm not.
Yes, I in my notes I've got you weren't shown this, but it may be that.
I think it was somewhere else.
Right. I think what what was relied on was oral evidence given at the trial 4 years later in 2019,
Yes.
and that's at tab 36.
Yes.
Yes.
And it's lines 21 where it starts. So that's that I think we were shown. So there's some vague recollection 4 years later, apparently, that Mrs. Vik says she thinks HSB was somehow involved. There was also evidence showing no material knowledge of the trust activities on the part of Caroline Vik, Mr. and Mrs. Vik's daughter. You don't need to look at that, but the reference is Supplemental Bundle Volume 3, page 979 at tab 35. And then there's Mr. Gunnell's evidence to the Connecticut court, and that's summarised in the judgment at 118 little 9. Now, that evidence is particularly significant. That's at page 210. Because Mr. Gunnell was directed to file an affirmation in the New York proceedings. And in the affirmation, which isn't in the bundle, you can get copies if you wish to see it, he stated that apart from 4 documents which related to his appointment as trustee, the resignation of Mrs. Esparago and a copy of the trust deed, he had no documents at all in his possession pertaining to the trust or Beatrice, and no knowledge of where such documents could be located or where they existed. So that's not somebody who's saying, yes, I ran the trust and I know all about it. Now, the other point is that none of these individuals had any relevant asset or investment management experience. And the judge recorded in relation to Mr. Broughton, at paragraph 160 of her judgment, the limitations that he had. And that's page 221 of the bundle. So, standing back, what you had is a trustee that had purported to put a very substantial amount of assets in trust for Mr. Vik's children, of which he was the grantor and the protector, that gave him pretty wide rights as to how that would be dealt with. We'll come on to the role of protector, and said that trustees could manage in their discretion, but either the trustees were members of his family who said they knew nothing about the affairs of the trust, or other people who appear to not certainly Mr. Gunnell doesn't seem to have had any knowledge, and none of them had the requisite expertise. And by contrast, Mr. Vik, with his very substantial expertise in finance and investments, undoubtedly would have been capable of managing assets. So the inescapable inference was that Mr. Vik was the person who knew what the assets were in Beatrice and the trust at all relevant times. And that's just looking at the trustee, the identity of the trustees and their evidence. But there were also many other factors that supported that conclusion. So, for example, the 730 million in assets Mr. Vik used to settle the trust came from SHI, which was Mr. Vik's creature company and personal trading vehicle. So they were effectively Mr. Vik's own assets, and you've seen that through all the judgments I've shown you. He admitted that he wanted to keep a close eye on his children's inheritance, of which the trust formed part, and the judge recorded that in her judgment at paragraphs 118 little 7, 141, 150, 152 to 154. He also, we say, as protector of the trust, and the word protector is, as Model Lord Justice Nugee, I think, said, not without its significance. He could hire and fire trustees, and that's clear on the terms of the trust deed as well. We looked at that, and it's recorded in the judgment at paragraph 1186. And he saw his role as looking after the trust and his assets, according to his evidence at the Part 71 hearing. I think the judge recorded that at 142 to 150 of her judgment. Now, my learned friend said yesterday, and that's at the transcript at page 148, that it was already known what asset types were held in Beatrice because that was what had been transferred in 2008, and the evidence was there had been no change of policy. That was lines 148, line 21 to page 149. And that is wrong, we say. Mr Vik's evidence to the judge by the end of his cross-examination was that he did not know what Beatrice's assets were as at August 2015 and December 2015. And I'm going to come on to look at that passage later, but the reference is, it's page 80 of the transcript, lines 12 to 17, and that's in Core Supplemental, tab 6, page 57.
So is the point that if he didn't know by 2015, because he said he had no knowledge of what the trustees were doing or what the managers were doing with the assets, that doesn't lie easily with the suggestion that it's all cash and non-cash assets sitting there?
How does he know?
How does he know?
Precisely. So there are lots of inconsistencies in this case, which the judge recorded. And we also know, and this is another point that was never properly grappled with by Mr Vik, that Beatrice wasn't just sitting on its assets, because there were in fact multi-million-dollar transfers that took place between Beatrice and SHI over a 4-year period after the trust was settled. And the transfers couldn't have taken place unless Mr Vik ensured that Beatrice continued to have assets sufficient to fund SHI. And the judge recorded that in paragraphs 173 to 193 of the judgment. Yeah. And as the judge held, he lied and gave inconsistent evidence. So his inconsistent evidence on the knowledge of the transfers between SHI and Beatrice is at Supplemental Bundle 1, tab 6, page 236 to 238, because it was very hard to follow what Mr Vik's case was as to who was authorising these transfers, how they came about, why there were these transfers from Beatrice to fund SHI's litigation costs from a trust that was said to be entirely for his children's benefit, managed by independent trustees. How would independent trustees allow SHI to be borrowing money to fund litigation costs? There'd be no rational reason for that. It would be a breach of the trustees' duties. And no explanation. It was all obfuscation. And these were examples the judge gave. So what we can see is that the judge very thoroughly and diligently went through a lot of material to reach the conclusion on multiple bases that his evidence in the Part 71 hearing was a lie. Now, Mr Vik says, notwithstanding that, the judge committed 2 errors. So first, he says the judge misinterpreted the answers he gave at the Part 71 hearing. And this is Mr Vik's skeleton, paragraph 77 to 86.
Isn't it more misinterpreted the questions he was asked?
It's not very clear, but I think below it was merely me who was criticised for my questioning. Now it's the judge, but we'll come on to look at quite what the case is because it's changed. This is a very interesting area of Mr Vik's case. And secondly, it said that the judge drew flawed inferences about his knowledge of the assets in Beatrice and the trust, and that's the skeleton at 87 to 126. So turning, ground 5 is misinterpreted Mr Vik's evidence. And essentially the complaint is, when he denied having any knowledge of the assets of Beatrice and the trust at the Part 71 hearing, he meant only he didn't know exactly what assets they had as August and December. And the judge's ultimate conclusion was that was hopeless because Mr Vik didn't understand or answer the questions in that narrowly circumscribed way. And they were general questions directed at ascertaining whether he had any knowledge of the assets at all. And she noted in in her judgment at 122 that his answers at the Part 71 hearing could only be understood in context, and that the context plainly included the history of the proceedings, with which Mr Vik was very familiar, having been embedded in the litigation, as the judge observed at paragraph 69 and 101 to 102 of the judgment. And can I just make the point, which I know your Lordship will have in mind, that the context also includes the nature of a Part 71 questioning, which I'm not sure any of your Lordships will have sat in on, because it's normally, I think, a master now who sits on it.
It can be heard before a judge.
Well, this one was heard by Mr Justice Cook, but
I had the misfortune once or twice.
yes, well, you'll know then, my Lord and my Lady, that it's an information gathering exercise. Even calling it a cross-examination isn't quite right.
No.
Because the debtor, as per Part 71, is ordered to turn up and provide information. And Part 71 specifically enables the judgment creditor to obtain information for the purposes of enforcement. And the debtor is required to turn up and provide information and documents. And it's an inquiry where the judgment debtor is essentially trying to get enforcement information. So some of the questions, as you will have seen, were trying to get Mr Vik's answers as opposed to putting a case, because at times it wasn't clear what the case was. It was simply, do you know what the assets are? Now, Mr Vik well knew that, because he had resisted all of this process, and he knew he was turning up as the officer of SHI to give information. And we'd gone round, as with everything with Mr Vik, we'd gone round the houses because he claimed that he hadn't been properly served. And we went through, could he be served when he was in the jurisdiction, and we had a whole fight about that. But once it was accepted he was properly served, he knew that the purpose was to find out where SHI's money had gone, which of course was in the background of him having moved it himself. And Mrs Justice Cockrell expressly recognised in her judgment that the examination process requires the debtor not only to give true answers, but also to provide information within his knowledge relevant to the question put. Because Mr Vik tried to have a go at striking out the application, all of that was ventilated in her judgment, and that was at paragraphs 236 to 238. And it was also reflected in the Part 71 order itself, which is in the core supplementary bundle at tab 19, page 134, which stated in terms the purpose of the order was for Mr Vik to attend court to provide information about the judgment debtor's means and any other information needed to enforce the judgment or order. So it's a deliberately very wide order consistent with the nature of CPR 71.
And you gave him the list of topics.
We did.
Is the judgment debtor or the director of the judgment debtor under any obligation to familiarise himself in advance with the matters he's going to be asked about?
Well, I think the answer to that is that if somebody is attending court bona fides with the express purpose of providing information or any other information needed to enforce the judgment and bring documents, and in this case, which was unusual, one doesn't normally provide a list of questions or ask for the documents in the way that we did with all that notice. It's even more so. What we would say it's implicit that one would take all reasonable steps, if nothing else. Now, in Mr Vik's position, of course, as the previously sole owner and director of the judgment debtor, who had been the only person who had been managing its assets, we submit, he had was a litigation consultant who worked for SHI2, Mr Johansson. It was Mr Vik. We say, of course he did, but it would have been within his own knowledge anyway. So the short answer is yes to a point, but particularly so in this case.
Okay.
And we would say, if you're going to come to court to comply with an order, and you thumb your nose, so Mr Vik's case about the Part 71 questioning prior to his cross-examination at any event was that he did have knowledge about the assets of Beatrice and the trust, just not the answers to the questions posed. That was his position. And he, of course, didn't say that in answer. He said categorically no to questions. And there are 2 points. One is that I think the judge considered that he obviously did know the answer and wasn't telling the truth, and actually the questions couldn't be construed in that way, and I'll show you why. But secondly, as I've said to you, when you read the passage that my Lord Justice Males mentioned, particularly I think it was page 57 over the page, you will see that his entire case collapsed because it was nothing to do with the precision of the questions. He said he just knew nothing. And that demonstrated the lie. So what we can say is that the full sequence of the questions need to be looked at in the context of Part 71 and also the history of this, which is Mr Vik had been very clear as to what was happening because he had challenged this so many times. And the purpose of the Part 71 hearing was expressly to establish the asset picture of the disappearing assets, including those of Beatrice, and to find out where that money had gone. And again, that's an unusual situation. A judgment debtor may be asked not about specific assets, but the location of any assets. Here, this is a man who had stripped specific assets, and we wanted to know where they were. So he knew what we were asking in the context of Beatrice. Turning then to the Part 71 hearing, half of the morning was spent on Beatrice and the trust, taking Mr Vik through a structured sequence of questions which took up about 40 pages of the transcript. And the relevant answers start at Supplemental Bundle 1, Tab 1, page 8, through to page 19, and those are internal transcripts 20 to 63. And the questioning can be divided loosely into 7 parts. First, Mr Vik was asked generally about the assets that he had settled on trust in 2008, their value at the time, and whether he'd transfer any assets into the trust subsequently. That was pages 20 to 22 of the internal transcript, 8 to 9 of the bundle. Second, he was asked about whether any assets had been revested in him, according to the powers of the trustee. That was at pages 24 to 25 of the transcript, pages 9 to 10 of the bundle. Third, he was asked how closely he monitored the affairs of the trust, how the trust was operated and by whom, and it was those questions that revealed for the first time that he had recently resigned as protector of the trust on the 5th of August. And those were pages 25 to 33 of the transcript, 10 to 12 of the bundle, and it was page 26, lines 7 to 19 about the resignation. Fourth, he was asked about dealings in Beatrice's assets after the company was moved into the trust, and who would have carried out those dealings, and certain alleged loans from Beatrice to SHI. And that was pages 33 to 36 of the transcript, page 12 of the bundle. Fifth, he was asked about fund transfers between SHI and Beatrice after the formation of the trust. And there are approximately 100 in total between 2008 and 2012. That's recorded in the judgment at paragraph 188. And that was at pages 36 to 59 of the transcript, 12 to 18 of the bundle. Sixth, he was asked a series of general questions about transfers into Beatrice or the trust, whether by himself or anyone else. And that was 59 to 60 of the transcript, 18 of the bundle. And seventh, he was asked about the assets of Beatrice as at the date of the Part 71 hearing in December and August 2015. And the contempt charge, in answer to my Lord Justice Nugee's question, related to that final part of the questioning specifically, and that was at page 61 of the transcript, line 23, to page 63 of the transcript, line 20, and page 8 of the bundle. Sorry, yes, page 8 of them. And the relevant section was specifically identified in the grounds of contempt, and that's in the core bundle, tab 11, page 309. And I don't know whether your Lordship has looked at transcript and wants to look at it again.
Well, I don't think I've looked all through pages 20 to 63.
No, I meant that passage at paragraph 61. It's page 61, where the contempt arises from.
All right, well, let's look at that because I think there was one question about knowledge of SHI assets held by Beatrice, which I just wanted to clarify.
So it's core supplemental.
Core supplemental, is it?
Yes, that's right.
Tab 1, I think.
Tab one, thanks.
So which was that last one we're looking at?
Page 61 of the transcript, page 8 of the bundle.
Thank you.
So if we start at line 23, see the questioning that goes on to page 62 and 63. And what we see is 61 line 23, I ask, can you tell the court what assets Beatrice currently has, i.e. at the date of the Part 71 hearing? The answer is a definitive and unqualified no. I asked him what of SHI's funds Beatrice was still holding. His answer is, I don't know. Page 62, line 17 to 19, I asked if he could tell the court what assets Beatrice had in August 2015. His answer was again a definitive and unqualified no. And then in a series of follow-up questions, which started at page 62, line 24 to page 63, line 9, he was given repeated opportunities to explain why he was unable to shed light on Beatrice's assets at August 2015, and given every opportunity to qualify or elaborate. And his final emphatic response is at page 63, lines 9 to 10.
When at 64, lines 10 to 12, he says the commercial rationale was that with the win in the litigation, they would have received a lot more money back. Is that a reference to the $8 billion counterclaim which was held to be dishonestly pursued?
I assume so,
Yes, I see.
but I don't know, I'm afraid. And then when we go to page 63, at line 11, I then asked Mr Vik when the last time was he knew what assets of the trust were. And the exchange is between lines 13 to 20. So what you can see from that line of questioning is that Mr Vik was not being asked if he knew precisely what assets Beatrice and the trust had. It was generally whether he had any knowledge of their assets, and the answer was definitively no, he didn't. Now, his whole case in evidence was that he understood the questions differently and would have therefore had given different answers if different questions had been asked. But then if we go to tab 6 of this bundle, as you know, he proceeded to try and distance himself in the cross-examination from the trust in its entirety. And what then happened was he was saying that he didn't know anything at all. So, for example, at page, if we start at page 75, and go over the page, you'll see. I put to him, you know exactly what assets Beatrice had. He said, that's wrong. And then you see lines 22, your case is that you didn't understand what was being asked. Your case is that you weren't clear at the dates it was being asked. Estimates of December, you couldn't remember what it was in August. And you didn't understand what questions were being asked. And then if we go over the page to page 77, line 11, you could have told the court in answer to the questions, the ones I've shown you in Part 71 transcript, what the position was in December 2015 if you didn't remember what it was in August, because there was a suggestion you couldn't remember in December what the position was in August. I could have if I knew it, but I didn't know. So your case is that you didn't know what the position was in August or December, and therefore you don't need to advance a case that you didn't understand the questions. Your case is simply you knew nothing. Which is it? Now, what you can see if you read the next 4 pages internally is the him obfuscating and the judge asking me to put the question again and again. So you see on page 78, Mr. Flynn, would you like to put your question again? And then line 19, thank you, Mr. Flynn, Mr. Vik obviously doesn't want to answer the question. It's then put again on page 79. And then again, so it's put again at line 5 and again at line 17.
It's quite clear from the second time you put it on page 78 that A, he didn't want to answer the question, and B, the judge got the point.
Yeah, exactly. So you can see against that background, the judge rightly dismissed Mr. Vik's argument that he misunderstood the questions, which was the heart of his defence to contempt charge that he had lied about Beatrice in the Part 71 hearing. He said he didn't lie because he didn't understand the questions, and you can see that that completely unravelled. And what you can see from what I've shown you is the judge could have actually just relied on this, and that would have been an end to it. But instead, actually, the judge went through everything and gave multiple reasons, including the terms of the trustee and so on and so forth, and examined all of his evidence to give a whole multiplicity of reasons why his evidence was to be disbelieved. Now, Mr. Vik challenges the judge's decision on a number of grounds. So first of all, he says that the judge took a wrong approach as a matter of law to the evidence he gave at the Part 71 hearing. Now, that argument has no legs, and we think that my learned friend pretty much conceded that to my Lord Justice Nugee's question yesterday, and that was at the transcript at page 153, lines 14 to 23, because the exercise, he accepted the exercise was a question of fact, and it wasn't some form of construction of the transcript like a legal document. So that, if that is coming back, I'd like to know, but as I understand it, that argument has gone. We've addressed it anyway as to why it's wrong, paragraphs 101 to 112 of our skeleton. The second point is that Mr. Vik criticises the conclusions the judge drew about his understanding of the questions posed at the Part 71 hearing. And these criticisms are at paragraph 85 of his skeleton. And they are wrong for 4 reasons. The first reason is that Mr. Vik says the questions were most naturally read as asking for the precise assets and Beatrice and the trust, and I've already answered that. The second reason, Mr. Vik says that prior to answering the questions, he had provided evidence about the classes of assets in Beatrice and the trust. That's in his skeleton at 85, subparagraph 2, and that's wrong. And the part of the transcript of the Part 71 hearing relied upon just doesn't support that. and you can look at it. It's in the Core Supplementary Bundle, Volume 1, Tab 1 rather, pages 7 to 8, transcript 59 to 61. The short point is he makes no mention of asset classes, and he wasn't asked about asset classes. Secondly, there's nothing in the transcript of the Part 71 hearing that suggests we wanted to explore a distinction between classes of assets and details of assets, and the judge said that that distinction was wholly implausible. That's at paragraph 129 of her judgment. The third reason, Mr Vik says, is that the bank needed to know precisely what Beatrice's assets were to enforce against them. That's 85 subparagraph 3. And that assertion proceeds on an entirely false premise that the information that Mr Vik could provide about the assets in Beatrice and the trust would only assist the bank's enforcement if there is the precision he claims he didn't have. And then the fourth point is that his case collapsed anyway for the reasons I've shown you on the idea of precision or non-precision.
Well, what's quite interesting about the passage that you've shown us is that he almost disavowed the "I didn't understand
Yes.
the questions" line and tried to pin it on his counsel.
Yes.
Oh yes,
Really a legal matter.
yes. Well, we had that a lot. There'll be other passages I'll show you when we come on to disclosure of the documents that I think a number of people came in the firing line, but not Mr Vik. And then, my lady, my lord, the remaining criticisms are set out in Mr Vik's skeleton at paragraphs 85, 4 and 5 and 86, and we respond to those in our skeleton at paragraphs 112D, E and 113. And I think we've given a response. They take matters no further. So, my lord, that is ground 5, and I'm coming on to ground 6, which I can do now or wait for tomorrow.
Well, I take it we're in plenty of time.
I would happily rather continue. I didn't know whether you wanted to stop at 4:15, but I would rather continue and deal with ground 6 today if you're...
How long will it take you to do ground 6, do you think?
I don't know, I'm sorry to say. Hopefully 15 minutes.
Yes.
That would be good, because then I'd finish Beatrice then.
Yes, all right. Well, why don't you
Thank you.
finish that?
So I'll turn to ground 6, which is the flawed inferential reasoning. By this ground, Mr Vik says that the judge made 5 allegedly material errors, and these are at paragraph 93 of his skeleton, and we say that none of them stand up. The first alleged error is that Mr Vik says the judge's conclusion that he retained considerable legal rights to control the assets of the trust was wrong. Now, the judge's reasoning is set out at paragraphs 140 to 141 of her judgment. And that is at page 217. And you can see that her findings about the nature of the trust were nuanced and expressed carefully. And contrary to what Mr Vik says in his skeleton at paragraph 98, her reasoning proceeded expressly on the basis that Mr Vik may not have exercised any of the powers he had under the trustee. So you can see that from the very start of paragraph 140. And the judge was plainly entitled to reach the conclusion she did as set out in paragraph 140 based upon the terms of the trust deed, which I have shown you, and the involvement of Mr Vik's immediate family. And I've given you and shown you most of the references. The only other reference I should give you is that in Article 3.1 of the trust, which is Core Supplemental, tab 22, page 167, Mr Vik retained power as settler to approve all distributions from the trust. That was the only one I think I missed when I was going through it. So your Lordship has seen all those provisions, and that conclusion is clearly justified. The second alleged error, according to Mr Vik, was that the judge inferred that he regarded his role as protector as going beyond simply appointing or removing trustees, so as to require him to take care of the trust more generally. Now, my learned friend conceded yesterday that a protector could not sensibly be in a position to exercise any of those powers without knowing something about the performance of the trust and its underlying assets. And that's in the transcript of yesterday at page 168 to 170. The judge's reasoning is at paragraphs 142 to 150, and her key conclusions are at paragraph 149, the final sentence, and paragraph 150. And that's page 219. And her reasoning is impeccable, and there was ample evidence to support the inference drawn. And again, I've got on this topic 5 points. First, Mr Vik himself gave evidence at the Part 71 hearing and the committal hearing that he regarded the purpose of the protector as to take care of or protect the trust. And in particular, the protector's role included preventing the dissipation of trust assets. And for your lordship's note, the Part 71 hearing reference is supplemental volume 1, tab 1, page 11, at pages 30 to 31 of the transcript, which are quoted by the judge in her judgment at paragraph 144. And the committal hearing is supplemental volume 1, tab 6, page 245, at transcript pages 62 to 63, quoted by the judge at 143 of her judgment. The second point is that Mr Vik's attempts to downplay the protector's role at other points during the committal hearing were internally inconsistent and not credible. And this was discussed by the judge at paragraphs 145 to 146 of her judgment. And you can look at the underlying evidence in the core supplemental bundle, tab 6, page 47, at pages 9 to 11 of the transcript. Third, Mr Vik was unable to offer any credible explanation why he remained the protector for 7 years, if not to look after its assets or affairs. A point made by the judge at paragraph 146 and taken from his evidence core supplemental bundle core supplemental bundle tab 6, page 47, at page 10 to page 11 of the transcript. The fourth point is that Mr Vik resigned as a protector shortly before he was served with the Part 71 order.
It says after at page 147. Judgment 147.
That's right. So, sorry, after.
I think you said before.
Oh, sorry, shortly after. Sorry, I've obviously misread my own notes. He resigned shortly after he was served with the Part 71 order, a connection that the judge found was not without significance at paragraph 147. And the clear inference was that he wanted to create distance between himself and the trust in the context of the Part 71 order. And fifth, the trustee lacked any relevant investment management experience, despite the vast sums held through the trust interest in Beatrice, as I've shown you. And plainly, as the judge held at paragraph 150, someone other than the trustees needed to take care of the trust affairs. And I've already made the point about the investment type. So, in light of that body of evidence, Mr Vik's attempt to manufacture an error or inconsistency in the judge's interpretation of his evidence falls away, and we set that out in paragraph 123 of our skeleton. The third alleged error by Mr Vik relates to third-party managers. And it's said that the judge found that the trustees lack any experience or knowledge to manage the trust assets. Now, that's at paragraphs 151 to 165 of the judge's judgment. Now, Mr Vik appears to accept those findings, and you see that in his skeleton at 108, sub 3 and 109. And it's abundantly clear that the trustees had no knowledge from the material I've already shown you. Against that background, the judge drew an inference that someone else must have been supervising and managing the investment to the extent deemed necessary in the trust and Beatrice, and that's at paragraph 166 of the judgment. And again, Mr Vik doesn't appear to challenge that inference, and that's at paragraph 1081 of his skeleton and 109. And the judge rejected Mr Vik's speculation that someone else supervising the investments were third-party fund managers appointed to manage Beatrice's assets. That's at the judgment 156. And rather, she concluded on the evidence at paragraph 157 that the inference is clear that Mr Vik would be the person with the knowledge and control of the assets. Now, it's this last conclusion that Mr Vik challenges, having accepted everything before. And what he says is that the judge was wrong to dismiss Mr Vik's alternative inference that there were trustees supervising Beatrice's assets with the assistance of third-party managers. And that's 109 to 114 of his skeleton. The short answer is there is simply no credible evidence to suggest that any third-party managers supervised Beatrice or the trust affairs. Mr Vik produced no evidence to demonstrate any third parties were ever involved in the management of the assets of the trust or Beatrice. If third-party fund managers were involved, Mr Vik should have led evidence to prove their involvement, and it wouldn't have required Mr Vik to have a legal right of access to the trust documents, as he suggests in his skeleton at 113. He presumably would have had direct knowledge from the time that he served as protector for the 7 years, if any fund managers were involved.
So when you say a moment ago, no credible evidence that there were managers appointed to manage, you mean no evidence at all, rather than evidence but not credible?
The only evidence he now points to is that passage of Mrs Vik's deposition, where she says, I think HSBC.
Referring to HSBC.
That I've been cautious in saying no credible evidence. I mean, the reality is there's no evidence, but insofar as your lordship thinks that might count, it's not credible evidence to show there were third-party managers.
I understand you now. Thank you.
And what he now says is HSBC or Zimmerman and Ghosh might have been acting as third-party managers. This is in 1121 of his skeleton. And that is pure speculation, because even now, despite his application to reduce three applications to reduce 5 new pieces of evidence, there's nothing there. And surely one could have got a letter to confirm the position. He points only to the vague statements that I've mentioned made by Mrs Vik, but the statements alluding to HSBC managing Beatrice and its supposed loan facility can't be given any weight.
Well, the submission that it is perfectly possible
Exactly.
that they assisted in managing rather underlines that
And it
there is
was.
no evidence that they were.
Exactly. And it's also, my lord, contradicted, in fact, by Mr Vik's evidence during a 2015 deposition, Mrs Vik's evidence during the earlier deposition I showed you, when she pleaded complete ignorance of Beatrice's business operations and assets. So the second point is that Mr Vik didn't actually deploy that evidence below in support of the case that Beatrice had third-party investment managers. So it's a bit surprising that the judge is being criticised. That evidence was in fact relied on by Mr Vik to establish a different point, which was that HSBC, it was said, was managing the supposed SHI Beatrice credit line, which I'll come on to next. And you can see that in Mr Vik's written closing submission at paragraph 48. And the reference to that is Core Supplemental Bundle, tab 18, page 127. And the oral closing, Core Supplemental, tab 8, page 63, at transcript page 44 and transcript page 47. So that's the case they relied on below. So that evidence was not even mentioned for that purpose. So Mr Vik is actually changing his case on appeal as to what inferences are to be drawn from his wife's testimony. And as your lordship, my next point is going to be, as your says, might be drawn from his wife's testimony, or even should be. So the judge couldn't have safely inferred that there were third-party managers operating alongside the trustees to manage Beatrice. But even if she could have done, her inference that Mr Vik was keeping a close eye on its assets would still have been sound. So it doesn't actually help Mr Vik's case anyway, because who would have supervised the third-party managers? Picking up one possibly related point, it was suggested this morning, around page 7, we think, of the transcript, that Mrs Vik, so it's day 2, page 7, that Mrs Vik was independent of Mr Vik, and Mr Matthews relied on the refusal to supply documents when she was asked. I think, as one of your Lordship or Ladyship pointed out, that's not evidence of independence. The context was because Mr Vik had refused to disclose Beatrice's documents in connection with the October 2008 transfers. The judge ordered Mr Vik to write to Beatrice to ask it to supply documents. Mrs Vik's refusal was precisely what Mr Vik wanted and wanted to show, namely ensuring relevant documents were not then before the court. Mrs Vik's refusal to supply the documents was before Mr Justice Cook at the trial, and he held Mr Vik had access to Beatrice's documents and those of the trust. And you can see that in the trial judgment at paragraphs 1452 and 1574. So it's a thoroughly bad point. And I think then the fourth alleged error, which I'm hoping it's not quite the final one, it's almost the final one, concerns the judge's finding that Mr Vik must have kept a close eye on Beatrice's assets to ensure it could fund the SHI Beatrice credit line. And the judge's findings are at paragraphs 193 and 200 of the judgment, and she sets out her reasons underpinning that finding at 176 to 192 and 197 to 200. And even Mr Vik accepts the judge's treatment of this issue was very detailed, and you can see that in paragraph 115 of his skeleton. The criticisms levelled are unsustainable, and I think there are two main criticisms. First, Mr Vik implausibly asserts that the transfers between SHI and Beatrice were too trivial to warrant his attention. That's paragraph 119 of his skeleton. Now, this was a credit line involving over 100 transfers. It transferred, as far as we know, $80 million US, and it represented a net transfer to SHI of $25 million US. And it was all at a time when Mr Vik was the sole director of SHI. And you can see all of that was put to him. It's from the Supplemental Bundle Volume 1, Tab 1, page 12, to 13, transcript 36 to 37. So Mr Vik, with his close attention to detail, as the judge found in paragraph 62 to 64 of the judgment, undoubtedly would have kept himself abreast of the status of the credit line. And somebody had to know what was going on the SHI side, if not the Beatrice side. And again, Mr Vik just couldn't explain that. And the judge rejected the argument, therefore rightly, at paragraph 200. It was one of the more, how to say, absurd elements of Mr Vik's case. The second criticism made is that he says Zimmerman and Ghosh would have managed the transfers on the credit line without his involvement. That's paragraph 1194. And as the judge rightly found, there was no credible or documentary evidence to suggest Zimmerman and Ghosh ever performed such a role. And that's in 186 of her judgment. And that conclusion was entirely sound and was based on 5 points. First, statements from Mr Vik's daughter in a 2017 deposition, and which is recorded at paragraph 176 of the judgment, who had no recollection of any of the transfers between SHI and Beatrice and said she knew nothing about Zimmerman and Ghosh. Second, Mr Vik's evidence at the Part 71 hearing that he would make a request to Zimmerman and Ghosh, apparently on behalf of SHI, he said, and they would take care of matters, shall we say. And that was at page 38 of the transcript, supplemental 1, tab 1, page 13. And that was coupled with his acceptance that he had disclosed no documents to show Zimmerman and Ghosh arranging any of the transfers. And that was in the same reference, but at page 41 of the transcript. So if Zimmerman Ghosh had been taking care of matters, as Mr Vik claimed, documents showing this would undoubtedly have been produced by Mr Vik, but they weren't. The third point is that his evasive evidence at the Part 71 hearing as to how and via whom Beatrice authorised the transfers spoke volumes, and you can see that recorded in the judge's judgment at paragraph 185. Fourth, his contradictory and evasive evidence at the committal hearing as to who precisely was authorising the transfers was illuminating, and that was in the judgment at 184. And then finally, his evidence that he was aware of the transfers but knew nothing of their detail, that's recorded in the judgment at 189. And secondly, that Beatrice was also unaware of what SHI was using the funds for, that's in the judgment at 191, was completely contradictory and implausible, because it was unreal to suggest that Beatrice would have done that Mr Vik would have been ignorant about it, but somehow aware of them. A fortiori, when he was the sole director of SHI, and his evidence was that the counterparty Beatrice knew nothing of the detail, it spoke volumes that he just couldn't explain it, or his role, or SHI's knowledge, or what Beatrice was doing. And all of this, of course, was post-2008. So the judge made no errors in relation to her treatment of the credit line, and all her findings were very detailed. So, my lord, I've gone over the time. I have one last point to finish, which I can do tomorrow.
Right. How long do you expect to be tomorrow?
I think I'll have my full time, which I think takes me to, I think Mr Matthews sat down around 12 o'clock. So I'm assuming about 3:15.
Right. All right. Well, if we need it, that then gives Mr Matthews an hour to reply. Very good. 10:30 tomorrow. Yes.